Hello again, and welcome to our Governing Health podcast. I'm your host, Michael Peregrine. As we all know, much of the activity in the boardroom is focused on the exercise of our fiduciary duties, trying to gain a better understanding of what exactly they call us to do and to whom, or what, we owe those duties. But there's a related question that doesn't get asked enough. Who cares how we exercise those duties? And in the nonprofit healthcare sector, that's the State Attorney General. She, or he, is the state's chief legal officer and has responsibility for supervising and safeguarding the assets of charities located in the state, and is also responsible for monitoring the exercise of fiduciary duties by board members of those charities. The Attorney General has broad statutory and common law powers with respect to those duties. And as we all know, there's been quite an enforcement focus on these issues of late in the nonprofit healthcare sector. So we've invited a great expert on the subject to share his perspectives with us today. My friend Jim Sheehan is the chief of the New York Attorney General's Charities Bureau, which oversees compliance and regulation of the nation's largest charity sector. Prior to this role, he was the New York City Human Resource Administration's first chief integrity officer, overseeing audit, investigations, and data analysis for the nation's largest social services agency. From 2007 to 2011, he was New York's first Medicaid Inspector General, overseeing the country's first mandatory compliance program and New York's leading role in healthcare data analysis. Jim's name is also well known to many healthcare lawyers for his notable work on False Claims Act matters while an assistant and associate U.S. attorney in the Eastern District of Pennsylvania. But before we turn to Jim, let's pause to revisit a theme we've discussed from time to time here on the podcast, and that's the critical role of the board's compliance committee in maintaining oversight of the organization's compliance program. In that role, the committee has particularly important responsibilities with respect to assuring that the compliance program is effective and up to date, and also working with the board to address issues associated with internal and external investigations of malfeasance. Those responsibilities have been significantly clarified by the recent release of two important guidance documents from the Department of Justice. One provides a detailed update on how DOJ evaluates compliance plan effectiveness, and the other addresses how an organization may obtain cooperation credit from DOJ with respect to an investigation. Committee members would greatly benefit from a briefing on both of these guidance documents. And now my conversation with Jim Sheehan, Chief of the New York Attorney General's Charities Bureau. Jim's joining us by phone today from New York. Jim, welcome back to the program. It's nice to have you with us again.
Thank you, Michael. I appreciate the invitation.
Jim, let's kind of kick things off with a basic discussion. I think that'll be interesting to all the folks who are listening today. How would you describe the focus of your office's jurisdiction?
So the responsibility of the Charities Bureau in New York and most other states is very state-specific. And what we do is we have a governing statute, the nonprofit corporation law, and governing statutes called the executive law, which relate to fundraising. But as far as governance is concerned, the nonprofit corporation law is key. And what that gives us is the responsibility for representing the interests of unnamed charitable beneficiaries of all nonprofits in New York State that are charities. And part of that is a registration requirement, part of that is a filing requirement, part of that is oversight for actions that are taken by boards and by organizations in the interest of the charity.
So the Charities Bureau has a substantial role to play with respect to New York charities.
So we confront issues in one of four ways. One is every year, all nonprofits that are not hospitals and religious organizations file their 990, their what's called a Char 500, and an audit report with us. The hospitals in New York file with the Department of Health. But these documents, both the ones that are filed with us and the ones that are available from GuideStar or the IRS, give us basically a data line to understand where our charity organizations sit. The second thing that we use are complaints and inquiries we get from the public, from media, and from elected officials saying they have a concern about a specific issue. The third is whistleblowers, people who work for large organizations or are vendors or contractors, or beneficiaries in some cases, who come to us and say, this is my experience with this organization, they're not doing what they're supposed to be doing. And the final group is cooperating witnesses. That is, once we start an investigation and people are motivated to come and tell us more information about how that organization operates.
How do you evaluate the credibility of the information you get from third-party sources? Do you place media reports like those from the New York Times at the top of the list?
Well, you talk about the papers, but in 2019, long before a story appears in the Wall Street Journal, the New York Times, the reporters are out doing their homework and making inquiries. And what happens in response is often people will call us, not just because they are vendors or they're employees or whatever, but because they've been contacted by the newspaper or by electronic websites saying, "Tell me what's going on here." And in terms of credibility, you make a judgment. One of the great things about having the IRS 990 and other data available is you can test the allegations or the information that a complainant or a whistleblower is providing against those 990s to see how likely they are to be accurate and complete. And of course, when you have multiple inquiries, that raises some other issues too.
Jim, what's the role and how do you view the electronic media in terms of a source of information about potential wrongdoing?
What we are finding is, in terms of confirming that there's something there, it's very, very helpful to see what else is out there on the web. And again, there's all kinds of garbage on the web as well as all kinds of useful information. So you're not going to go proceed on a case just based on what you see. But what you're trying to do is to test the credibility and the knowledge of the people who come to us with information, and that can be very helpful.
Usually, how do you then approach the charity? Is it with some type of formal proceeding or a phone call or other inquiry? What's the normal way for a charity to know, whoops, we have an issue here?
It's a great question, and the bureaucratic answer is it depends. If it's an embezzlement case and it involves senior executives, that involves one kind of investigation, which is not where we call you up and say, do you have a problem? Most other cases, our goal is in obtaining compliance from the organization. So we will generally reach out to the organization and say, we have a concern about governance, or we're looking at your 990, and can you give us an idea of where you are? For example, in New York, a charity is not permitted to lend money to its officers or directors. So we did a data run on the 990 for New York State and found 135 entities that had loaned money to their officers or directors. And so our goal there is not to publicly embarrass the organization, because they are charities and they have a mission, but to get them to be in compliance with the law. And that's by letter or by phone call.
One more administrative question. You have a very large Charities Bureau, very qualified people and hardworking folks. How is your office organized? That might be of real interest to the folks who are listening today.
So we have 4 different units. Unit 1 is registration. I talked about some of the filings that people have to make, and that's a significant group. We also respond to inquiries and requests for assistance in accessing the information we have. The second unit is our trust group, and the responsibility of that unit is to make sure that donors who have given money to charitable organizations, the money is used as was instructed by the donor, and in cases that involve estates or trusts, that the charitable interest is protected against other interests that may try to chase that money down, like family members. The next group is transactions. So every charity that disposes of all or substantially all of its property in New York is required to get the approval of the Charities Bureau. And our job there is to make sure that they're getting fair value and fair terms for their property, and also that the proceeds are used appropriately. And the final group is enforcement, and that's what you would expect.
It would seem then, Jim, that with respect to an industry sector like nonprofit healthcare, that could transcend all of those divisions.
Or transcend or have some contact with each of those divisions. That's correct.
And what are you seeing right now in terms of hot buttons in the nonprofit healthcare sector today?
So one of the very big issues for us is the issue of nursing homes. And the nursing home industry is changing very quickly. A lot of these nursing homes are owned by hospital systems or healthcare systems. Some are freestanding, and it's getting more difficult to run a freestanding nursing home today as a nonprofit entity. So there's a lot of interest in selling. And the buyers are typically for-profit nursing home chains. Our concern is, if you look at the literature, that nonprofits as a group do a much better job of managing nursing homes, caring for patients, and creating patient satisfaction than for-profits. And so we can't say you can't sell, because there are circumstances in which that's appropriate, but we do ask, what are you doing to protect the people who live in that facility? What are you doing to protect the charitable mission of the entity after the sale? And are you focused on the quality of the new operator as well as the sale price?
Let's stick on that quality issue for a moment. As you know, there have been a number of very high-profile and extraordinarily tragic instances of quality of care at major non-for-profit health systems that have resulted in patient deaths, whether infants or adults, and almost always through rogue conduct. To what extent do you see the jurisdiction of your office extending into quality of care incidents?
In my prior positions, the Medicaid Inspector General and the Associate U.S. Attorney, this was one of my primary responsibilities, is looking at quality of care failures in charitable organizations. And the look was specifically on what the institution had been doing before and after. We do have a healthcare bureau in the Attorney General's office which looks at those issues. My interest in this current position is more in the institutional controls. And the institutional controls both to measure the risk of patient harm and, after there is a problem, to how the organization responded. And that particular set of issues are institutional. So, if you think historically, the criminal prosecutors will go after specific individuals who committed the harm. My job, the job of the Charities Bureau, is to look to see what kind of institutional controls and risk detection and measurement processes were in place. And this adopts a lot of the Caremark type strategies which have existed in the for-profit sector for a while, saying you need to have these kinds of systems and controls at the board level and make sure you're responding to these issues as they arise.
I think we mark that one for future discussion. Let's pivot now for a moment to our regular short segment, What's Trending Now, when we try and flag a new governance issue we see on the horizon. And for me today, it's the need for the board and its compliance committee to focus more closely on preserving the organization's culture of ethical behavior. For indications are that the smartest guys in the room, those people willing to push the envelope too far, are still around. Just read the papers. They're the ones willing to operate with few boundaries in the gray zones, the ones who aren't worried about the moral issue. And it's complicated by the fact that there aren't many sitting officers and directors who served in those roles during the Sarbanes and Enron environment. They haven't experienced that breadth of scandal. Board leadership can, and perhaps should, consider re-emphasizing a tone-at-the-top approach to ethical standards within the organization. Now let's turn back to Jim and his thoughts on how state charity officials interact with nonprofit health care. But let's kind of go to a specific instance that is proceeding along in the New York courts, and I think it would be a terrifically strong interest to some of our health system representatives listening today. Let's chat a little bit about the Lutheran Homes case. Okay, so there's an organization in the Hudson Valley, which is the eastern part of New York, involving Lutheran Care Network. And in 2015, we filed suit against Lutheran Care Network. They had a corporate structure where the Lutheran Care Network was the sole member of a series of senior centers, nursing homes, and a residential facility.
and they were taking the money out of the senior residential facility that was an apartment complex and using it for other purposes, including paying the salaries of the senior people within Lutheran Care Network. And the residents complained at the Coburg Village, which is the facility. And the response of the organization, and the board complained, the response of the organization, that is Lutheran Care Network, was to fire the board and say, from now on, the board of the sole member will be the board of Coburg Village. The president of the Residents Association invited the president of Lutheran Care Network to a meeting, and not surprisingly, the residents demanded to know why the money was being taken out of their facility, why the quality of services was declining, and he was sufficiently upset at the reception at the meeting that he then turned around and told this 80-something resident who'd been there for over 10 years that his lease would be terminated in 30 days, and he had to leave. That's when we got involved, both for the issue of the governance issues, but also that did he have the powers as the head of a charity to force somebody else out of his apartment after 10 years on 30 days' notice. And we filed our suit. We had an adverse decision from the court at the trial level, went up to the third department, which was the intermediate appellate entity in New York State, and the court sent the case back down, essentially, and this is a paraphrase, my paraphrase, saying, there's a specific corporate purpose for this charity, which is running Coburg Village, and you have a responsibility, if you're the sole member, to make sure that the money in that organization is used for the mission described in the organization's founding documents.
What's the relief that you're seeking in this case?
We're seeking two kinds of relief. One is we want a board that is independent at Coburg Village of the sole member, and a commitment from the sole member not to interfere with their decision making. And the second is we want a return of the money which was taken improperly from Coburg Village to Lutheran Care Network.
And what's the status of the case?
It's in discovery after the remand to the Supreme Court, which is our trial court, and I'd expect a trial sometime in the fall or early spring of 2020.
Let's kind of keep on the same enforcement level, Jim. It's always been my focus that in many of the state's enforcement actions, one of the remedies you seek from board members is a ban on future nonprofit board service. While that's not unique to New York State, it certainly is a compelling remedy. Could you talk a little bit about the history of that remedy and why you think it's important?
Sure. The one power of the board in most nonprofits under the common law or under the bylaws is removal of a member of the board. Our statute allows for removal of the board, and the case law says that removal includes you can't go back to any board. And the idea is that if someone is so derelict in their fiduciary duty, it evidences a lack of understanding what their responsibility is. And under certain cases, it makes sense to say they cannot serve in a fiduciary capacity again in the nonprofit sector. And we've been successful in getting both agreed upon permanent bars and also court-ordered permanent bars.
What does that say about your perspective and your office's expectations about board service, especially in directors of some of the nonprofits with 9, 10, and 11-figure annual revenues? What are you looking for in terms of the performance by these fiduciaries?
So let's go back a step. The permanent ban or a longer-term ban is not the first remedy. You want to make sure that both the members understand their responsibilities and that the institution, that is the board and the officers, have some kind of system or process in place to educate their board members, to remind them of their fiduciary responsibilities. The New York State statute, the not-for-profit corporation law, is in some ways like a cookbook. It says, here's what you have to have. You have to have a conflict of interest policy. You have to have a whistleblower policy. You have to have a disclosure of potentially conflicting interests. If you have a related party transaction, there are certain protections that are built into that process as well. And the idea is, all you have to do is look at the statute to say, what are your responsibilities and, what do you have to do to fulfill them? And in our experience in New York, most organizations do that. I think it's very important to understand that most directors of nonprofits are volunteers, and we want to encourage that volunteer spirit, and that the first remedy in most cases is making sure that systems and processes exist to remind directors of that and to help them perform it.
As I recall, you're unique in terms of a state with a particular focus on the performance of the audit committee. Can you speak to your guidelines there?
Sure. First, there's the statute. The statute says over a certain dollar figure, which most healthcare systems obviously will be, you must have an independent audit committee. You must have an independent auditor who's engaged every year to perform an independent audit. There has to be an interaction between the auditor and the audit committee, and including a series of steps which are consistent with the AICPA standards. And we have been, again, the same idea. We reach out to professionals and say, here's the expectations, here's what we understand the requirements are, and here's how we're going to read the audits. And remember that every audit, virtually every audit in New York of organizations, ends up being reviewed by us.
Jim, before we break, I ask you, you have a unique perspective given your former history as a federal prosecutor and your involvement in the Medicaid program, and you've worn the hat of Chief Integrity Officer. As you view the healthcare sector right now with that experience, what message would you have for the general counsel and the compliance officers out there and for board members? What are the recommendations you would have in terms of enforcement with the charities laws? My
primary interest is not enforcement of compliance, and I think that you have to recognize the public spirit and contribution of board members, and board members have to recognize that they have a very important responsibility, including overseeing the executive and the officers of the corporation. And that often can be a painful or difficult duty. But one thing, board members are actively solicited in terms of hiring the executive director or the president or the chief executive officer. It's also important to be annual evaluations of both the CEO and other senior officers, and that there's an evaluation of board members. And the reason for this is you want to think about not just the numbers that the executive leadership gives you, but what is the underlying mission of the organization and how effective is compliance with that mission.
Jim, I think the folks listening today would be interested in your perspective on some of the controversies out there that relate to directors serving as vendors to the organization, which is a practice under most state law is appropriate under certain circumstances. Yet that's been the focus of perhaps the largest controversy right now we have going on in the charity world and healthcare. What's your office's view on directors serving as vendors?
I have serious concerns. Let me just start off. There are two things that happen in New York. One is there's a requirement of a conflict of interest report that every director is supposed to give once a year to whoever's in charge of handling those conflicts of interest. And the second is a related party rule, which says that the independent members of the board must make a judgment that this vendor is in the best interest of the organization to use that person as a vendor, and they consider other options, and this is why this is best, and that the minutes of the organization record that. I think that's a great prophylactic thing. What I find happens is conflict of interest issues are boring, and you have to upset people by asking difficult questions, and then you find out when something else goes bad that the media take a very hard look at those conflict of interest statements, as do we, to see what kind of effective governance procedures were in place at this organization.
Optics count.
Exactly.
Jim Sheehan, we thank you very much for joining us today and for your willingness to answer some of the questions and for your insight on the largest charities bureau in the United States. Thanks so much for joining us.
Thank you, Michael, and I wish the best to the people who are doing the hard work of running large and medium and small health systems in this country.
Thank you very much. Jim Sheehan gives us all substantial food for thought today. Boards and the senior leadership team should be aware of the role and jurisdiction of the State Attorney General and the need to address its issues and concerns not only in connection with the functioning of the board, but also in connection with strategic planning and transactions. It's important to remember that satisfaction of the state charity laws is both an important compliance issue as well as a key legal feasibility concern. Thanks so much for joining us for today's episode of Governing Health. Be sure to subscribe to the full complimentary podcast series. You can find us on iTunes, SoundCloud, and YouTube, as well as through the McDermott website. There you'll be able to stay up to date with all our future episodes and to re-listen to the old ones. Until then, this is your host, Michael Peregrine, saying thanks for listening.
This material is for general information purposes only and should not be construed as legal advice or any other advice on any specific facts or circumstances. No one should act or refrain from acting based upon any information herein without seeking professional legal advice. McDermott, Will & Emery makes no warranties, representations, or claims of any kind concerning the content herein. McDermott and the contributing presenters or authors expressly disclaim all liability to any person in respect of the consequences of anything done or not done in reliance upon the use of contents included herein. Copyright 2019, McDermott, Will & Emery, all rights reserved. Any use of these materials, including reproduction, modification, distribution, or republication without the prior written consent of McDermott is strictly prohibited. This may be considered attorney advertising. Prior results do not guarantee a similar outcome.